Ken, let's pivot to the federal election interference case as well. Trump's team just responding to the prosecution's motion for a partial gag order that would limit what the former president can say about the case, about witnesses. Walk us through their arguments against this gag order and what happens next.
Yeah, and Anna, I should say this is one of the biggest, most consequential pretrial issues in any of these Trump trials, because this would affect what former President Trump can say on the campaign trail. And it's part of his identity, and part of his campaign for president is to disparage the prosecution and in some cases the judge in these cases. And what the prosecution has asked is that the judge impose a limited gag order that would prevent former President Trump and others on his behalf from making statements about the credibility of witnesses or disparaging and inflammatory or intimidating statements about any party, witness, attorney, court personnel, or potential jurors. So that would obviously cover a lot of what we're seeing the former president say on social media. And his lawyers are pushing back and saying, look, the prosecution may not like President Trump's entirely valid criticisms, but neither it nor this court are the filter for what the public may hear. The lawyers add, let's be clear, the prosecution hopes to create a contempt trap for President Trump and his attorneys. So this is a big deal. The judge is going to have to decide it. It will almost certainly be appealed. It may go all the way to the Supreme Court. It's a real test for where is the line between the First Amendment rights of someone campaigning for president and the ability of a judge to restrict what a criminal defendant can do to potentially affect the jury pool.